Good afternoon and welcome to the Appellate Division First Department. Here is the call of the calendar. People versus State of New York versus Cecil Richardson is a submit. JG versus Cove Castles Development Corporation is a submit. Marcus Laddie versus JC is a submit. Elizabeth Fernandez versus Carroll LLC is a submit. Eduardo Sandoval versus Leake Watts Services Inc. et al. And Edwards. Appellant Leake and Watts. Ms. Ravage. Ms. Ravage, are you there?
I'm sorry. Good afternoon, Your Honors. Amanda Ravitch of Sher-Tremonti for Appellant Defendant Leake and Watts.
Good afternoon. You've been granted 5 and 2. Kelly Zick for Edwards.
Yes, Your Honor. I'm here. Kelly Zick from Miranda Sloan for Appellant Edwards.
Good afternoon, Ms. Zick. You've been granted 5 and 2.
Thank you.
Mr. Smith for Respondent Plaintiff.
Good afternoon, Your Honor. I'm Harper Smith from Rubenstein and Reinecke for Respondent Sandoval.
My apologies, Ms. Smith. You've been granted 7 minutes. That's what happens with assumptions. People v. Guillermo Ortiz. Appellant Gabe Newland.
Yes, Your Honor.
Good afternoon. You've been granted 5 and 2.
Thank you.
Mr. Croys for Respondent.
Good afternoon, Your Honor. John Corse for the people.
Good afternoon. You've been granted 5.
Thank you.
Jose Mateus versus Grey Dog Chelsea and West 16th Realty. Appellant, Mr. Channon.
Yes, Lester Channon for the appellant.
Good afternoon. You've been granted 5 and 2.
Thank you.
Respondent for plaintiff, Mr. Saveron.
Yes, Your Honor. Chris Savaro, Pog, Isaac, and DeSico on behalf of the plaintiff respondent.
Good afternoon. You've been granted 4.
Thank you.
And for Grey Dog, Joshua Talkovitz.
Good afternoon, Your Honor. Joshua Talkovitz from McManus at Teshaglu on behalf of Respondent Grey Dog.
Good afternoon. You've been granted 4 minutes.
Thank you.
National Waste and Recycling Association versus the City of New York. Appellant, Mr. Spolzino.
Good afternoon, Your Honor. Robert Spolzino from Abrams Fensterman.
Good afternoon. You've been granted 7 and 2.
Thank you, Your Honor.
Ms. McCampbell.
Good afternoon, Your Honor. Amy McCampbell for respondents.
Good afternoon. You've been granted 8 minutes.
Thank you.
People v. Jose Medina, that is a submit. Properties Hacker LLC versus City of New York, submit. Geraldine Duval versus Kaiser Nursing and Center Light Health, that's a submit. Gurasan versus Samantha Tejada, that's a submit. Certain underwriters at Lloyd's versus Bioenergy Development Group, LLC, et al. Appellant, Mr. Gonzalez.
Good afternoon, Your Honor. Matthew Gonzalez from Zell on behalf of appellants.
Good afternoon. You've been granted 12 and 3. Mr. Ortiz.
Good afternoon,
Did I say
Your
that
Honor.
correctly?
Yeah, that's pretty close.
Great.
Good afternoon, Your Honor. Dennis Ortiz, Anderson Kill for the respondents.
Wonderful. You've been granted 12 minutes, sir.
Thank you, Your Honor.
People v. Kevon Watt is a submit. Esther O'Mahony versus Wiston is a submit. Urbanite Wine Merchants, Inc. versus New York State Liquor Authority is a submit. People versus Gabriel Ramos is a submit. The Non-Human Rights Project, Inc. on behalf of Happy versus James J. Breheny I believe there is a pro hoc vici application. Ms. Stein, I will hear you now.
Yes, good afternoon, Your Honor. Elizabeth Stein for Appellant, the Non-Human Rights Project. I'm here to introduce my colleague, Attorney Stephen M. Wise of the State Bar of Massachusetts and President of the Non-Human Rights Project, and respectfully ask the court's permission for Attorney Wise to participate in this appeal and argue before the court.
Thank you, Ms. Stein. That application is granted. Mr. Wise, welcome, and you've been granted 4 and 2. Respondent, Mr. Manning.
Thank you, Your Honor. Yes.
Good afternoon. You've been granted 4 minutes.
Thank you.
Michael Benny versus Havana Central and Concord Partners is a submit. Deutsche Bank versus Suzanne Dawn Alexander is a submit. And Casimir and Associates versus Ezra Omri is a submit. First case on today's calendar is Sandoval versus Leake and Watts.
Good afternoon, Your Honors. Amanda Ravitch of Church-Monty for Appellant Defendant Leake and Watts Services.
You may proceed.
This is an appeal of a summary judgment decision where the essential facts are not in dispute. One of Leake and Watts's...
This is Justice Besmer. I have a question about the facts.
Yes.
I see that Ms. Edwards was suspended in December of 2011 for psychological abuse of a patient. I didn't see anything in the record concerning any steps taken to address this issue with her before the incident that later occurred that led to her dismissal. Is that somewhere in the record, or is there no evidence of that?
That is in the record, and I don't have it at my fingertips. I'll get it to you on reply, but or on my rebuttal. But yes, the incident was looked into. It was resolved, and she ultimately wasn't fired because of this, because the individual had severe autism, and it had been figured out that she just heard things very loudly. So Miss Edwards was told to speak softer around the defendant. But I'd like to just note that that fact is actually irrelevant here because it doesn't show any sort of issue of physical abuse.
Thank you. With regard to the fact that I'm sorry, I've forgotten his name, that the Eddie's, Mr. Sandoval's family had made complaints that he had bruises on him. I didn't see anything in the record regarding any investigation by your client as to the reasons for those bruises. Could you show me where in the record there's any evidence that your clients did any investigation as to that?
So I don't think there's anything in the record regarding those statements besides in her deposition testimony. And her deposition testimony was very general. She said
is it your testimony that there is no evidence that your client undertook any investigation as to her complaints that she testified to in her deposition?
No, that's not my testimony. The testimony is that Lincoln Watts did look into those issues, but that's
any evidence of that in the record?
Again, I don't have that at my fingertips. I will, on rebuttal, I will let you know. But those complaints were just. I'd like to make a few points on that. First, the plaintiff at issue here has a record of self-injurious behavior. So her general complaints about bruises just wouldn't have put Lincoln Watts on notice that there was some sort of issue of abuse. And also, it wasn't connected to the individuals here, Chavez or Edwards. So Lincoln Watts just had no prior notice that the individuals here, Chavez or Edwards, would have had a propensity for violence. The mother's complaints were just very general, and they wouldn't have.
Tell me where in the record there's any evidence that these two individuals were provided any training for how to handle clients who were aggressive?
Yes, so there's extensive evidence on that. The training is on the record at 969 to 1017.
Well, no, there's a document that talks about that. But what evidence is there that and they each got, and I believe she got some certificate. but what evidence is there that the trainings that allegedly led to that certificate actually addressed that issue with regard to how to treat aggressive patients?
Yes, if you look at page 1011 of the training material, there is a list of very specific techniques that the employees are trained on.
Perhaps I wasn't clear. What evidence is that this is the training that was given to these individuals?
Oh, I'm sorry. So on pages 900 to 903, it lists what's called skip training. It provides evidence that Ms. Edwards and Mr. Chavez went to these trainings. They're called SKIP. It's Strategic Crisis Intervention Prevention. And the materials for that, the training materials, are on 969 to 1017.
You may continue.
Okay. Thank you. So, one of Lincoln Watts' employees here intentionally burned the plaintiff with a hot potato masher, and it was a terrible act of violence. Under no theory can Lincoln Watts, as the employer, be held liable for this criminal act, which was not only unforeseeable, but was completely contrary to Lincoln Watts' mission and specifically prohibited by the training that I just mentioned. First, with respect to plaintiff's vicarious liability claim, an employer cannot be held liable for an act its employee commits outside the scope of his employment. Here, the plaintiff, Eduardo Sandoval, lived in a group home run by my client, Lincoln Watts, because he has severe autism and is nonverbal. Lincoln Watts' entire mission is to provide a safe home and protect people like plaintiff. Deliberately going into the kitchen and heating up a potato masher to burn the plaintiff in his own home was in no way part of the job of Mr. Chavez or Miss Edwards. This was not some sort of kitchen accident involving foreseeable employee negligence. It was a terrible act of abuse outside the scope of employment. Lincoln Watts has a strict anti-abuse policy, and its employees go through extensive training on how to handle these crises. Physical intervention is taught as a very last resort, but even where it's absolutely necessary, an employee is only allowed to use the very specific techniques listed in the training materials. As I mentioned, that's on 1011.
Counsel, earlier you mentioned that this particular client was someone who engaged in inflicted self-injury.
Yes.
Is there documentation of that? And had there been any other reports of him injuring himself so that in order to support your conclusion that his bruises that the mother complained about were indeed self-inflicted?
So I would say that it's unclear what the mother was complaining about, and just very general complaints like that it was not connected to the defendants here, right? The individual defendants here. It was not connected.
You say that, but how do we know that? So I ask because typically at these homes, parents are not permitted to come and visit the clients every day, which means that the intermittent visitation of family members would not permit a family member to be precise about when it happened. They can only talk about when they observed it, right? And so in light of that, according to the record, these two employees were your night staff. So the question is, were any of these reported bruises, did they coincide with a morning after these two employees were in charge of the house?
So I would say the evidence is unclear on that, because all the plaintiff is pointing to is very general testimony from the mother. The plaintiff has come forward with no evidence whatsoever that Lincoln Watts was on notice of a propensity for violence of Chavez and Edwards.
But isn't that the point? How could they, in light of the living circumstance and the way that these type of homes operate? A parent would not know until they have a an opportunity to visit with a child.
But that's what discovery is for. We're on summary judgment, and the plaintiff still hasn't been able to come up with a single fact that Chavez or Edwards, prior to this incident, engaged in any sort of behavior that was
This is Judge
an
Lloyd.
issue.
I don't mean to cut you off, but I want to ask you a question. When the mother testified about these injuries sustained by the child, by the individual here, I think I'm hearing you that your client did not have notice of this, that even though she testified to these bruises and what he had been inflicted on him, that your client didn't know about it. There was no documented notice to you that the mother told you about these incidents or these injuries?
No, Your Honor. If the mother, or when the mother made certain complaints, Lincoln Watts looked into them and didn't find any evidence that there was any sort of issue. And when there was an issue, when there was a clear issue where an employee engaged in wrongful conduct, Lincoln Watts did everything correct. They launched an investigation. They contacted the state regulators. They called the police. They fired Chavez and Edwards when they know their entire mission is to protect their residents. And when they know of something,
I understand that, but before I understand that, I'm talking about before this incident. I mean, when the mother testified in her EBT that she noticed bruises or injuries on her child, was that brought to your attention, your client's attention? That's what I want to ask.
Yes, and the mother also testified that she makes complaints all the time, and so yes, the employer hears from the mother that she says she's a mother. And she's
that's in the record that she's not making this up. She actually told you, your client, of these problems. Yes or no?
I think that's just in her deposition testimony, but I'm not disputing that she's communicated this to our client and that our client looked into these issues. But she's brought forth no evidence whatsoever that there was an issue.
Counsel, her testimony is evidence, of course. But what I am curious about is, I didn't see any evidence in the record that your client had investigated after receiving any of those complaints. Could you point me to where there's any evidence in the record that your client at any time investigated her complaints prior to this incident?
And I'm going to allow you to answer that question, and then we're going on to the next appellant.
Okay, I'll on rebuttal, I'll get back to you. Thank you. Thank you, Your Honors.
Okay. All right. Ms. Zick.
Yes, Your Honor. Kelly Zick for Appellant Ajalone Edwards of Miranda Sloan. So in regards to Ms. Edwards' appeal, it's my position, or our position, that the lower court erred in the denial of summary judgment on behalf of Ms. Edwards, and that the lower court relied erroneously upon facts in the record that I'd like to go through. The first that the court relied upon was an affidavit by Wendell Chavez, who is a defaulted co-defendant in this matter, also a Leake and Watts employee. And that affidavit was submitted by Mr. Chavez in response to a default motion that the plaintiff had brought against him. That affidavit was unsigned, undated, it was not notarized. And if you read it, Mr. Chavez essentially says he didn't do this act.
So this is Judge Kern. I'm going to interrupt for a second. Isn't there inherently a factual issue as to exactly what occurred that night? Since they were the only two people who were present, the incident happened, and no one knows to this day exactly whether both of them or just one of them was responsible, what occurred. So why is her mere denial of involvement enough to grant her summary judgment, since that's really all that there is to support her claim that she was not involved?
Right. So I don't believe that there is an issue of fact as to Ms. Edwards. Her testimony was clear, and you're correct. The only evidence we have of the three people in the home that evening that were involved was Ms. Edwards. Mr. Sandoval is unfortunately unable to testify, and Mr. Chavez, for unknown reasons, defaulted and did not appear in this matter. So aside from his affidavit that says he didn't do it, but also doesn't point out that anyone else did, I guess presumably he had the opportunity to do so in such an affidavit. Ms. Edwards' testimony was clear that the only contact she had with Mr. Sandoval that evening was when she physically placed her body in between Mr. Sandoval, who was unclothed in that moment, as he tried to run out and escape from the home.
Isn't it correct that she didn't report the injuries that night to anybody?
She was unaware of the injuries that night. No, if you read her testimony, she didn't become aware of them until at a later time.
But
So-
doesn't that apparently, I'm sorry.
There's a statement she made to the police 5 days later where she did finger Mr. Chavez and say, and she says in the statement, it's record 1281. I saw him use the potato masher. So when did she first come forward with that information to her employer or to anyone else?
Your Honor, I do know the notation that you're talking about, the statement to the police. I only know the date of that police report, and so presumably that would be the first time that she had said that. She did not testify to that during her deposition. During the deposition, she testified that she, again, was physically pressed against the door, did not see how Mr. Chavez led Mr. Sandoval away from her that evening, and that she didn't see any markings on his body until a later date, I believe 2 days later.
Why isn't that an issue of fact, though?
The police report, because
yes,
I don't, even if you take her statement to the police as being factual and that's what occurred, she did not commit the physical assault or the act upon Mr. Sandoval. Should she
but
have,
if she knew her co-worker was going to the kitchen to get that masher in order to get this client under control and get him off of the door and off of her, as she attested to, it seems to me that that's an open question.
well, Your Honor, it's on page 1281 of the record. So if you read the statement that she gave to the police, and I'm refreshing my recollection of it now as we speak, she did not say in the affidavit that she knew that he was going to do that as he went into the kitchen. She only knew that he got her, Mr. Sandoval, off of her, so to speak. And then as he was leading Mr. Sandoval away from her back into his bedroom, she observed the potato masher. So it wasn't
excuse me, counsel, wouldn't it have been enough cause for them to fire her that she knew about that and didn't tell anyone for several days? That would clearly be a violation of the regulation, or at least there's a question of fact about when she knew that and when she reported that. Isn't that enough to get us past summary judgment?
No, I don't believe so as to Miss Edwards, because as to Miss Edwards, we're talking about her negligence, right?
Right. Well, wouldn't she have been duty bound to go and check on this client to make sure that he was not injured by that potato masher in the hands of her coworker? Is she not obligated to do that?
If she did see him perform the act,
she said, according to that statement, she sees it in his hand after the client goes upstairs. Right. So if she does nothing, is that not an issue of fact for a jury to consider?
I don't believe it is. And the reason being that that statement also was on sign or on not notarized, but beyond that,
have to be, counsel.
Beyond that, and more importantly, Your Honor, the duty owed to her, if she did breach a duty, there was no causal connection between the injury to Mr. Sandoval, which would have already occurred by Mr. Chavez's assault upon Mr. Sandoval. So because of that, that's why I don't believe that Ms. Edwards had negligence in this action. And then additionally, the lower court erred in other reliances upon the record in reaching their decision. If I may go through them briefly. And then
I'll let you do that on your rebuttal time, okay?
Thank you.
Ms. Smith?
Good afternoon, Your Honors. I represent the respondent, Mr. Sandoval, and his family. I'd like to speak to the arguments made by Defendant Leake and Watts first. On their motion for summary judgment, it was their burden as to negligent hiring to demonstrate that they took all reasonable steps to investigate an employee's background before hiring them for a position. And of course, what is reasonable depends on what the position is. In this case,
Counsel, this is Justice Gesmer. I have a question about that. One of your allegations is that Leake and Watts should have gotten a response from Mr. Chavez's prior employer. As part of your discovery, did you ever find out the reasons for Mr. Chavez's the termination of Mr. Chavez's prior employment?
In discovery, should attempt
That it did you? I didn't see anything in the record about any showing by you as to what the reason had been for Mr. Chavis' prior termination. Did you? Is that in the record somewhere?
It's not in the record, Your Honor. We were unable to obtain that information. But it is their burden to establish they took the steps that were reasonable. And in a position that they're hiring for of residential habilitation assistant.
Is there any statutory requirement to do a background check? To check references, any of that? I mean, clearly it's good business practice, but is there any statutory, any legal requirement to do that?
I am not aware, Your Honor, of a statutory requirement, but it comes down to the question of what is reasonable for a position of someone who's entrusted to provide direct care for seriously vulnerable residents who have disabilities, who sometimes cannot speak for themselves, particularly if an applicant for that position has in his job application that he was let go from the only similar position he has ever held. In that case, it is reasonable for the employer considering him for another similar position to reach out and find out the circumstances. And the evidence is clear that they failed to do that. They failed to obtain a response to the letter. They failed to make any phone communication with the former employer. There's no evidence that they got an explanation from any source as to why.
Judge Kern, I want to ask you something about the negligent retention. Is your claim for negligent retention based solely on the allegation by the mother that her son had bruises? Is there anything else in the record other than those general statements that support your claim for negligent retention? Any other incidents of these two employees or anything that supports that and they had any other issues at the time they worked for their employer there?
As to negligent retention, as to Mr. Chavis, the mother testified that she had made complaints about bruises, and specifically she testified she had mentioned that her son Eddie appeared nervous around Chavis. Those two facts together put Leake and Watts on notice to do at least an investigation. There's no evidence in the record that they took any investigation whatsoever into those complaints. And with regard to Edwards, there is a question of fact as to notice of abusive behavior from the 2011 allegation. They claim that they looked into it and there was nothing to it, but there's no evidence in the record to support that. So it cannot be said as a matter of law that they had no notice of Edwards' abusive propensities. With regard to the claim of negligent training, the defendants provided training materials that were allegedly distributed to the employees at Leake and Watts, including SCIP, SCIP training. However, those training materials that were provided make no mention of instruction of techniques for physically restraining a resident in the rare occasions when that is necessary, such as when a resident is attempting to leave or is threatening violence against somebody else. There's no indication that proper training was provided to staff members for those type of situations. In the record, there is one page that's a certificate showing that Ajalone Edwards performed or took some type of course that involved some type of training in physical restraint. And there is no similar certificate in the file from Mr. Chavis. So they've failed to demonstrate that they acted reasonably in providing training for the staff handling this difficult position of caring for very vulnerable residents.
And Counsel, this is Judge Owing.
I'm sorry.
Go ahead, Justice Gessman. Go ahead.
As to the certificate from Ms. Edwards that you just mentioned, is there any documentation as to what materials were provided or covered or discussed at the training that certificate is supposed to evidence completion of?
There is not, Your Honor. The only evidence in the entire record of training for physical restraint of residents is page 821 of the record, that one-page certificate, and there's no indication as to what specifically that training involved, and there's certainly no indication that Chavis was ever provided with that training at any time.
So, Counsel, I have a quick question, Judge Owing. You mentioned about the training materials that were provided. You're opposing this summary judgment motion. Is there anything in the record here that you got some sort of expert to testify that this was insufficient, that these training materials and these whatever they provided to their employees was insufficient to raise a factual issue?
Your Honor, we did not retain an expert in this case. It's our position that there's a question of fact as to whether the training was sufficient or not, and that an expert is not required to say that some training in physical restraint is required for this position or should be required by a reasonable employer for such a position of trust with such
I don't
a
know that.
vulnerable.
I don't know that because, you know, when you're dealing with individuals with mental issues or severe disabilities, there may be special ways of handling the situation. And I don't know. I'm not an expert in that. And it would have been nice to see if, since you're opposing to raise a factual issue, saying, look, what you have here is just totally insufficient. It's not going to work.
There may be some physical risk.
Okay, I got it. Thank you.
Okay.
Thank you so much. Ms. Ravitch, you have 2 minutes.
Hi, yes, Your Honors. The plaintiff is completely misrepresenting the record. There are multiple things in the record that the plaintiff has omitted to mention. So I'd like to first say that with respect to the training materials on pages 900 to 903, it shows that both Chavez and Edwards attended multiple skip trainings on how to handle physical interventions if required. Regarding the verbal incident of Edwards, like I said, that's not relevant because it wasn't a physical incident, but Lincoln Watts absolutely did a full investigation. And if you look on pages 843 to 848, you'll see that that was documented. Regarding, I know Your Honors asked about whether there was any evidence of self-injurious behavior at the record at 893. You can see evidence there. With respect to the mother's complaints,
let me ask you a question, counsel. Let me ask you a question. One of the things you just said, the listing at 900 to 903 just lists the titles of the program. So we don't know what was actually covered or if they attended, or if they, if it was a half an hour program or it doesn't tell us anything about the content. It just lists that their names and a bunch of programs, right?
Right, but at pages 969 to 1017, the Strategic Crisis Intervention Prevention SCIP training, it bears the exact same name that's listed in the record. So it shows those are the training materials for the exact training that they were provided. And with respect to the mother's complaints, there is no evidence whatsoever that she reported this bruising previously, before her deposition. So it's the plaintiff's burden to show that the mother reported it.
Let me stop you there. As the institution taking care of her son, it is your institution that has to create a document about the complaint, not the other way around. So it would be you that would have it, not her.
That's absolutely correct. And if there was a complaint, we would have documented it and it would have been in the record and it would be here, but it's not. And so the plaintiff has come forward with no evidence that the mother contemporaneously reported this, that Lincoln Watts neglected to address it, or most importantly, that it was in any way connected to Chavez or Edwards. So we just have the mothers say so in this deposition. It's not enough to get past the line in summary judgment.
So who at Leake and Watts testified to a procedure for recording complaints and investigating complaints? Because you just told us there was a procedure. I don't recall in the record a procedure set out by anybody from Leake and Watts who was familiar with such a procedure, who described that procedure. Is that in the record?
I can't give you a page, I'm sorry, Your Honor, but that is their policy.
I understand you tell us it's their policy, or as you would say, your say-so. So where is that but you don't know where that is in the record or whose say-so it is?
I don't have a page for that, Your Honor, but I'd like to mention that the plaintiff 8 years later is still in Lincoln Watts's care. This is not a dangerous place. This was a
Counsel, that proves nothing. That may, services of this kind are not easy to come by. Thank you. Mr. Croyce. Oh, no, I'm sorry. Ms. Zeke.
Yes. I just want to highlight a few of the other erroneous foundations that the lower court relied upon in denying defendant Edwards' summary judgment motion. They cited that the police records were inconclusive. I would disagree. The conclusion of the police records were that Mr. Chavez was arrested. Ms. Edwards, while interviewed, was not arrested in relation to this act, and no criminal proceedings were brought in regards to Ms. Edwards. The lower court.
Is that the standard? Is that the standard here?
Well, the standard, if you read the lower court's decision, they said that the police records were inconclusive. So then in rereading the police records that are in the record.
Inconclusive on what issue?
Presumably that they were.
For me, it's for me, what's not conclusive is what she told the police and when and why it took her so long. If the police statement is correct, why it took her so long to report it to her boss. That to me seems to be the issue here.
The lower court didn't spell out or detail their basis of using the term inconclusive. That was my understanding and interpretation as I explained in my brief. The only other thing I would like to highlight to the court is that counsel for the plaintiff respondent did not have a strong or direct rebuttal to my brief, and that the lower court did not address my argument that the elements of battery or the punitive damages were not met in relation to this matter as to Ms. Edwards. Otherwise, if it pleases the court, I have nothing further.
Thank you so much.
Thank you. Have a great day.
You too. People v. Guillermo Ortiz. Mr. Newland, you have 5 minutes.
Thank you. Gabe Newland from the Office of the Appellate Defender on behalf of Guillermo Ortiz. Mr. Ortiz was deprived of his right to the effective assistance of counsel. In a prosecution for criminal possession of a weapon, defense counsel failed to pursue a winning argument to suppress the gun. He failed to provide informed plea advice. And when the case went to trial, he presented a defense that was not legally viable, leading him to elicit a confession from his own client on the witness stand. I'd like to begin.
I'm sorry to interrupt. Wasn't the lawyer handcuffed by the defendant's own statements about transitory possession?
No, not at all. And the key thing here is that counsel never provided informed advice. Counsel could have argued, if the case ever went to trial, that prosecution simply hadn't proven the case beyond a reasonable doubt. At the charge conference, counsel essentially acknowledges that he didn't know the law on temporary lawful possession. And because he didn't know the law, it was impossible for him to advise Mr. Ortiz about the viability of that defense or the desirability of accepting a plea offer. And his admitted ignorance of the law also led him to present a defense that wasn't legally viable. During opening statements, he's promising jurors that they're going to hear enough evidence that Mr. Ortiz was temporarily keeping the gun. But then later, he elicits Mr. Ortiz's testimony that he kept the gun for at least 3 days, a concession that his possession of the gun was not temporary, and then he was guilty of the alleged crime. Finally, counsel's failure to pursue a winning argument to suppress the gun in this case was not a result of strategy, but of counsel's failure to identify a pre-Miranda oral statement in which Mr. Ortiz admitted that he had a gun. Because that statement was a response to custodial interrogation, Miranda required its suppression. And because the discovery of the gun was a direct result of the pre-Miranda statement, the gun should have been suppressed as well. Counsel's failure to pursue these winning arguments dramatically altered the course of this litigation.
Wasn't your client the reason why there was a discussion between him and the police officers in the first instance? He was trying to give information so that he could minimize his own exposure on his drug arrest. Isn't that what happened here? Isn't that how this all got started?
That's definitely how it got started. But the key thing is, as the Court of Appeals is repeatedly made clear, that as long as the statements are in response to an interrogation, it doesn't matter if a criminal defendant has made some opening remarks by asking to cooperate. I'm pointing to the Court of Appeals decision in Rivers, where they held statements made in response to questioning are not truly spontaneous, even though the defendant may have made the opening remarks. I'm also looking at the Court of Appeals decision.
Except in those, most of the cases that you cite, we're talking about questions that go directly to the basis for the arrest. Here, the questions were, so tell me what you know about drug activity and gun activity in your area, right? He wanted to help himself, and that is what these officers wanted information on in exchange. So why should the police be held to account for a statement that they didn't ask about directly? They didn't ask him, do you have a gun? They said, tell me about guns in your neighborhood. How is that interrogation in line with the case law?
It's interrogation because the police asked Mr. Ortiz questions. It doesn't matter what the questions are about. If Mr. Ortiz is in custody and the police are asking him express questions, then that requires Miranda warnings. And as the suppression court found, this was interrogation.
Okay.
Wasn't.
Let's say I agree with you that this initial discussion without Miranda was ill-advised. Under this scenario here, the moment that he made an incriminating statement, the police immediately got the Miranda card and gave him his Miranda warning. So let's say I even agree with you that even that statement, because it is so close in time to the first statement, goes out. Why is the videotape statement not attenuated sufficiently so that that would be admissible?
So the key thing about the video statement is that it occurs the following day after the search has already happened and after the gun has already been recovered.
But does he know that?
Does who know that? I'm sorry.
The plaintiff, the defendant here, does he know that?
So that's not quite relevant. Whether Mr. Ortiz
counsel, forgive me, but what's relevant is what we deem relevant. So if I say to you that it seems to me that if he didn't know that they already had the gun, that fact is irrelevant in terms of this issue about the statement. It may have other issues with regard to whether it's fruit of the poisonous tree for a suppression on map, but in terms of the statement issue, we really only have to consider whether he was Mirandized the second time, whether it was attenuated, and whether the circumstances of that second videotape statement had indicia of any kind of coercion or any actions that would require suppression.
And I apologize if I wasn't clear. We're not challenging the admission of the video statement at all. What we're arguing is that the gun is an inadmissible fruit of the pre-Miranda oral statement. So on one day, you have the pre-Miranda oral statement, you have the written statement that comes immediately after that. Shortly after that, the police are applying for a search warrant that relies on the pre-Miranda oral statement and the written statement. Then they get the gun. Then the following day, they have a videotaped discussion in which Mr. Ortiz acknowledges that the gun was his. We're not contesting that the videotape statement should have been thrown out. What we're arguing is that the gun should have been thrown out and counsel should have argued to suppress the gun.
But it's still the same thing, because if they had waited a day, right, to get the search warrant based on the good videotape statement, they eventually would have had the probable cause they needed to get the search warrant.
But in this particular case, there's no argument here that this was the inevitable discovery doctrine applies here. This is very clearly the search warrant application relies on the pre-Miranda statement and then the written statement that comes immediately after that.
Okay, all right.
And so because of counsel's failure to argue for suppression of the gun, which is a fruit of the pre-Miranda oral statement, because of counsel's failure to provide informed plea advice, and because he elicited a confession from Mr. Ortiz on the witness stand, his advocacy repeatedly fell below the level of performance our Constitution demands, and the court should reverse his conviction.
Thank you. Mr. Croix, we will hear you now.
Good afternoon, Your Honors. John Croix for the people. Defense counsel provided effective representation in a case that is clear from the record was an obvious loser. And that ultimately answers all
But doesn't that beg the question? Isn't this an instance where this attorney, in light of what you just said, should have exercised his right to not allow this witness to take the stand?
I don't think so, Your Honor, because the situation that defense counsel found himself in was that defendant wanted to go to trial and didn't want to take a plea. So at that point, defense counsel is dealing with the only argument here that had any chance of success. We're not saying it was a good argument. It's clear that defense counsel understood it wasn't a good argument.
But the defendant was not the only witness that could have asserted this defense, right?
I disagree, Your Honor. Defendant was absolutely the only witness who could have given testimony about when he says he found the gun. Defendant was the only person who could. Defendant's narrative at the trial was that he found the gun under a bench. He was alone. He found it there. He took it back to his house. He was the only fact witness that could have testified to that. And as Justice Mandelbaum found in his decision, this was a line of argument that defendant had been insisting on pursuing the entire time. He'd been warned it was a bad one. He'd been told he should take a plea. He didn't want to do that. He made a huge record. He with the police at the grand jury, this record again and again and again saying it was transitory possession. Now, as my opponent points out, transitory possession was a hard argument here, and Justice Mandelbaum did not buy it. But at the end of the day, we have a defense counsel faced with a client who won't take a plea, who wants to go to trial, who is presenting one clear narrative of what happened that sticks him. I think the narrative of handcuffs was used. I think that's exactly right. He was stuck with the facts that he had. And they weren't good facts, but he made a colorable argument given what he had. And that's not ineffective assistance of counsel, Your Honor. As to the suppression issues, defense counsel did not argue for suppression of the gun and bullets because there's a United States Supreme Court case saying he couldn't get it. I think that's a complete answer to the issue of whether he should have made that argument. There's no New York authority to the contrary. In fact, this court we cite it in our brief, I think it's People v. Brown, actually addressed a very, very similar issue where a defendant was arguing that his lawyer was ineffective for not making a suppression argument that could have led to the suppression of a gun. And this court came back and said explicitly, look at Patane, look at this hostile Supreme Court precedent. There was no chance, it didn't have that likelihood of success that we're going to require if we're going to say that a lawyer fell below the standards of professional competence, right? So I think ultimately at the end of the day, Your Honor, defendant brings up a lot of individual points, but if you look at them, you are dealing ultimately with a situation where he is the reason that those are the situation. He is the reason that this argument, it was the only argument left. He got his good plea advice. He was told he should take one. He was told his arguments were not winning ones. And he didn't. And a lawyer going to trial with everything that he had was the best he could do, and it's not ineffective. Thank you, Your Honors.
Thank you so much. Mr. Newland, you have 2 minutes.
This case shouldn't have gone to trial. It depended on counsel effectively litigating a suppression motion and providing informed plea advice. Counsel didn't provide informed plea advice. He made clear in the charge conference that he didn't know the law on temporary lawful possession. It was impossible for him to advise Mr. Ortiz before trial about that law and whether he should be going to trial because counsel didn't know the law. Another point about suppression, respondent just says that there's no New York authority that required suppression of the physical fruits of the Miranda violation. That simply isn't true. This court has expressly left the question open, but the Second Department has very clearly held that physical fruits are required to be suppressed. And because there's no binding authority from the First Department, that decision was binding on the suppression court and the post-conviction court at the time of the suppression hearing. In the context of an ineffective counsel claim, we're looking at what the law was at the time of representation. So in January 2017, there are several cases from other departments, including People versus Jeffrey, that says physical fruits should have been suppressed. Counsel wasn't aware of this law. His billing records show that he didn't do any legal research. He moved only for suppression of the post-Miranda statement and the post-Miranda video statement. This was clearly not a matter of strategy, and there was a winning argument for suppression. We ask that you reverse Mr. Ortiz's conviction.
Thank you so much. Mateus versus Gray Dog Chelsea and West 16th Realty. Mr. Channon, you have 5 minutes.
Thank you, Your Honor. I represent West 16th Realty in this case. It arises out of an accident that occurred on February 19th, 2015, wherein Jose Mateus was delivering some linens to the Gray Dog restaurant on West 16th Street. He goes into the restaurant, which is on the ground floor, asks somebody to open up the cellar doors, or he says, I have these linens to deliver. How do I deliver them? They say, wait outside. We'll have someone open the cellar.
This just is molten. So your defense is that you're not a possession landlord.
Yeah, among other things.
Do the facts contradict that because of the way the super behaved with respect to the cellar and the bulkhead and the stairs down to the cellar?
Not in the least. The super said those cellar doors are the restaurants. I don't touch them. I don't repair them. I've seen them welding them. I've seen them plastering around the edges. The restaurant installed a temporary vestibule in that recessed area below the sidewalk, right abutting up against the restaurant. They had complete dominion and control over those cellar doors, which were locked from the inside. You had to go into their restaurant and go down the stairs and through there and up another staircase up to the cellar doors where you unlock them. And so they had complete control.
Did Mr. Martinez ever do that?
Martinez did that before the restaurant took occupancy. There was an error in the judge's opinion to the effect that Martinez did that after Gray Dog took possession. In fact, the record, as I state very clearly in my brief, clearly states that, and Martinez clearly stated in his testimony, I never went down there through the cellar doors or touched.
That was going to be my question, Justice Kern. Didn't the super specifically testify that once the restaurant took over the premises, he never used the cellar doors?
Exactly. Yes, that's what I was trying to say if I didn't say that.
Mr. Channon, yes. Question. With respect to this temporary vestibule that was
Yes.
erected by the restaurant, did they obtain permission from the owner to erect that vestibule?
They were asked, Peter Stein, who is the owner of the Gray Dog, was asked about that at deposition. He says not that he recalls. So he doesn't, he obviously was acting autonomously, but he didn't say one way or the other. He says, I don't recall. But
Did
he would,
the lease language between the owner and the restaurant require obtaining such consent?
I would have to pore over the language exactly. I do know in practice that there's nothing to indicate that they ever did. The super essentially was completely hands-off as far as the restaurant goes. In fact, the owner of the restaurant said, I don't want that guy down there, he's a thief. And that I never call him for anything. I call the office if I need to, for whatever reason, contact the landlord. So this was a situation where the restaurant was running the show 100%. This was their vendor who was delivering their linens, who supposedly went back up through those cellar doors with a bag of soiled linens and opened them himself, which went against this express protocol of the restaurant that they would have a sentry posted there every time these doors were open and would lock the vestibule doors every time those cellar doors were open, and now there seems to be some inference that perhaps they weren't locked, but in any case, if they weren't locked, it was the restaurant's responsibility in that. And as far as the arguments that are raised by both other parties about the administrative code and Rule 7.210 and the He decision, that is a case that involved an accident on the sidewalk. And while it is the cellar doors, under some provisions in the administrative code, can arguably said to be part of the sidewalk for purposes of the responsibility of the landlord, this was not an accident that happened on the sidewalk. This was not an accident that happened on the cellar doors. This was an accident that happened underground in private property, when someone was climbing up out of the recesses of the cellar, and supposedly the cellar door fell down and hit him. It has nothing to do with them making sure that the cellar doors are perfectly smooth and that the surface that pedestrians walk on, which is the intention of 7210 under 19101D, which defines sidewalk. They say it has to be, the sidewalks is intended for the use of pedestrians. This was no pedestrian. This was a delivery guy underground, not traversing
You got it, Mr.
sidewalk.
Shannon. You have 2 minutes on rebuttal. Mr. Savaron, you have 4 minutes.
Good afternoon, Your Honors. Chris Savaro on behalf of Jose Mateus. I would just like to note that while we're talking about the super, he clearly has no understanding of what the lease actually calls for. The only provision in the lease that pertains to what the tenant's obligations are to the actual sidewalk says that the tenant is responsible for doing trash removal and keeping it clean and doing snow and ice removal. And yet,
But this didn't happen on the
sidewalk, though. This accident did not happen on the sidewalk. This accident happened on the cellar stairs, and the cellar stairs the lease says that the stairway is part of the lease premises. So what does the sidewalk have to do with this case?
Well, I don't think that we can divorce, as counsel argues, I don't think we can divorce the fact that the cellar doors, which are typically flush with the sidewalk and what open up to give access either to and from the sidewalk towards the basement.
But his accident had nothing to do with the fact that there was something on the cellar's door, or that something was slippery on the cellar door, or that something was hanging off the cellar door. The accident had nothing to do with that. The accident had to do with him being on the stairs in the basement trying to come up the cellar doors, and the cellar doors closing him. Whatever happened on the sidewalk has no relation to this lawsuit.
Well, let me just say 2 things in response to that. And the first thing would be that this does have something to do with something not hanging on to the cellar doors, which are part of the sidewalk. And that something would be either a spreader or a lock to keep it open. So if we're talking about an obligation of a property owner to maintain
Counsel,
the hardware connected.
this cellar was for the use almost exclusively of the restaurant. There's no question about that. And there is no statutory obligation for the landlord to alter or affix any kind of bar that the restaurant could have done, since they're the ones using it.
Okay, if we respectfully disagree, and I'll rely on my briefs arguments for that, but even if there's no statutory...
So how are you going to distinguish Cuthbert then?
Excuse me?
How are you going to distinguish the case of Cuthbert, which seems very similar to this case? In terms of the responsibility for having some kind of latch to keep the cellar door open.
Okay, I'll distinguish it in 2 ways. The first would be that, as I was saying before, that Hoteling says that even in the absence of a statutory duty, landlord has a common law duty. And here in Cuthbert, the leaseholder had no day-to-day obligations with respect to the property whatsoever, and that's a huge distinguishing factor. The lease itself provides numerous obligations on behalf of the landlord to maintain the structural integrity of the property, of which the cellar doors are a part. And irrespective...
Counsel, you are basically saying that a landlord who has a premises that has a cellar door, even though they have a tenant for that premises that uses that cellar door almost for their exclusive use, that the landlord, if they have a superintendent in the building, has to park someone outside the door of that cellar in the event that the tenant uses it?
No, Your Honor, I'm not saying that whatsoever. I'm saying that when they have lease obligations for the structural integrity and safety of the building, they should be able to recognize a clear risk.
Structurally unsound. There's no structural defect here.
The structural defect is that it has no safety devices and it's located right by the door. It's a clear.
Isn't that exactly what Cuthbert said? Wasn't that the exact scenario in Cuthbert and a number of other cases from the First Department, where they said the lack of a bar on the cellar door to keep it open is not a structural defect, contrary to a specific statutory provision, and therefore there was no liability of the owner?
Your Honor, the lease provisions here are different than in Cuthbert. Under the lease here, they had the tenant couldn't make any alterations or repairs without without West's express approval. They had the right to reentry at any point to make whatever repairs they wanted on no notice whatsoever.
But the fact that
and I would say also
the fact that they could come and if they wanted to, as you say, put a bar on this gate doesn't mean they were required to.
Under the common law,
and
they should.
that their failure to do so somehow makes them liable for a failure on the part of an employee of the tenant.
However, Your Honors, I think that since this defect had existed since 2010, all the way through 2015, that I think the more analogous case is this court's decision in Hernandez 148, 83rd, 554, which was a decision that both Justice Manzanet and Justice Gesmer were a part of. I don't see how that case, which is more analogous as to the actual landlord's lease obligations, is trumped by Cuthbert. Hernandez is on complete fours, whereas in Cuthbert, they did not have the same day-to-day obligations, both under the lease as well as having an employee there.
In Hernandez, somebody got hit by a cellar door while underneath the cellar door?
Excuse
me?
me?
I don't believe those were the facts there. So I don't see how you can say they are exactly on all fours.
The cellar door struck the restaurant worker on the head. The only difference is that it was a restaurant worker as opposed to a delivery person, but I don't think that the obligation is any different with respect to safety.
Okay, I'll take a look again.
Thank you, Your Honors.
Thank you. All right, Mr. Talkovitz.
Good afternoon, Your Honors. Joshua Talkovitz on behalf of Gray Dog. I would just like to also ask this court to affirm the lower court's decision denying West 16's summary judgment motion. Most of the points that I'd like to discuss were hit on by plaintiff's counsel, but I would like to point out specifically with respect to the argument that, that West 16th was not out of possession. West 16th relies and states that the court below found them to be. The court below never found them to be an out of possession landlord, Your Honors. And in fact, it's our position, and I believe supported by the record evidence, that they were not out of possession.
Counsel, what evidence is there that they were in possession of the cellar stairs, which is where the accident occurred, and that wasn't part of the leased premises?
So the cellar stairs were, Your Honor, were not part of the leased premises. Looking at the lease itself, it was the store formerly known as Maroons, and about a portion, and they were allowed to use a portion of the basement. But the cellar stairs were not part of the demised premises under the lease agreement. And the accident didn't necessarily happen due to something on the stairs. He happened to be on the stairs when he was hit on the head with the door, but the accident occurred due to a defect in the hardware of the cellar door itself, that being the lack of a safety mechanism to close it. And for that reason, they're not necessarily out of possession with regard to the cellar doors. And I think that what's also on point to this is if you take a look at Article 9 of the rider of the lease, it's page 397 of the lease agreement. I'm sorry, of the record on appeal. It specifically states that the purpose of that provision is that the landlord shall exercise control over the outside of the premises. And the cellar doors are part of the outside of the premises. And when we're talking about whether or not they were an out of possession landlord with respect to that portion of the premises, control is one of the most important things here. And we have a lease that says they're going to exercise control over that portion. We had a super who lived in the building, walked by that area every single day, shoveled snow on the sidewalk in that area when it snowed. And for those reasons, well, beyond that, actually, let me just make the point that he also testified exactly how the doors worked. He knew how the hinges worked on the doors. He's opened the doors in the past. And for those reasons, he was aware of the fact that there was no safety mechanism on this door. Now, I understand what Your Honors were saying earlier to Mr. Sovero regarding whether there's any statutes that says they have to put that safety mechanism on. And there's nothing here specifically saying you have to do this. But what is of point is that an expert found that given the situation here, we had a cellar door that was otherwise an unsafe position, unsafe. And what 19152 A62 says, it defines the requirements under 7210 and notes that a landowner has to repair a cellar door that's otherwise in an unsafe condition. It leaves open what that unsafe condition might be. And it's
but basically what you're arguing is you want us to hold as a matter of law that any building owner with a cellar door must put a safety device on it, or they have failed to correct a defective condition.
Not necessarily. What we're arguing on appeal is that West 16th never met their prima facie burden of proving that the cellar doors were in a reasonably safe condition. And as an in-possession
the only thing that you are asserting that makes it not safe is that it doesn't have a safety bar or some safety mechanism, that the doors were not altered to add a safety mechanism. Am I missing something?
As far as our position, it's our position that these doors should have had a safety mechanism.
Okay, counsel, this is Judge Owen. Sure. I'm listening to this argument here. I think the threshold issue that the plaintiff and you have to get over is whether or not the owner is an out-of-possession owner. Because if the owner is an out-of-possession owner, if they are out of possession and that's it, where are we going from there? Where are we going from here? And the way I look at it is that the only way you're going to show, or at least raise a factual issue, that they are not an out-of-possession owner, is that if there's any contractual, provision that ropes them in, that gets them to still have control over those doors, those sidewalk doors that close. Okay, and I looked at the Hernandez case, and then Hernandez, the court, the first part, we actually found that the owner in that case actually continued to maintain or obligated itself contractually to maintain the basement doors. I don't see that here. Is there a lease provision that says, other than repairing the building, is there a specific provision that says that the owner is obligated to maintain the basement doors?
There's no specific, I think there's 2 points to this. Specifically, word for word, that they need to maintain the cellar doors, no. But what was not demised to my client was these cellar doors. And what the lease...
Wait, hold on a second. Wait a minute. What's demised to your client is the basement, right? Your client has the basement, correct?
Demised, my client's allowed use of the basement under a license, partial use of a part of the basement.
Okay, so which means that they get to use the basement. Okay, partial or not, they get to use the basement. They can use a corner of the basement then. Let's just, for argument's sake, I buy your argument. They get to use a quarter of the basement. Wouldn't that also mean that they have to use the door too to get to the basement?
Well, they can go through the restaurant as well, Your Honor. There's actually...
Right. Okay.
But
so
I think
we're trying to split hairs here, but you can't overlook the practical, obvious nature of what's going on here, right?
I hear what you're saying, but I actually think one thing.
Thanks. I'm glad you hear what I'm saying.
No, I do. But I think what's on point here, though, is that we're saying, well, if they're out of possession, or what I'm hearing from you is, if they're out of possession, then there's no way you're keeping them in. And I think what we argue, and I think it's a key point of both my brief as well as plaintiff's brief, is that under 19152 and how it ties in with 7210, the cellar doors were unsafe. He v. Troon has largely done away with this.
We don't even get there yet. We don't get there yet because you either have the contract or you have a course of conduct. And here the superintendent testified, you know what? He doesn't even use that. He after your client took over got leased the premises, he had to whatever he did. He hardly ever used the basement. So I don't even get to the administrative code part until you get to satisfy me that there's a factual issue that the owner is not an out-of-possession owner.
Well, thank you so much. We are out of time, gentlemen. National Waste and Recycling Association versus City of New York. Mr. Spolzino, you have 7 minutes.
Good afternoon, Your Honors. May it please the court. My name is Robert Spolzino. I represent the Appellate National Waste and Recycling Association. Our brief sets forth a number of reasons why Local Law 152 should be set aside. I'd like to use my time to talk about 3 of those issues. The first being the fact that it violates the Solid Waste Management Plan. The second, that the city failed to take the hard look required by seeker. And the third, that the city impermissibly segmented its seeker review. With regard to the Solid Waste Management Plan, Solid Waste Management Plan specifically addressed the issue of reducing permitted capacity at transfer stations by saying that the city had to negotiate with the solid waste transfer station owners, and if they couldn't reach a negotiated agreement, then the city could adopt legislation. Solid Waste Management Plan was never changed. Solid Waste Management Plan to be changed requires the approval of the New York State Department of Environmental Conservation. Okay? The Commissioner Doherty, in his written testimony in 2013, said that they had reached an agreement with the transfer station owners, but that the council chose not to pursue it. The Commissioner Diaz in 2015 said the same thing. The city's argument is that they chose not to pursue it because the property owners did not agree to reduce the actual amount of waste they were receiving, and thus the proposed voluntary reductions wouldn't have taken trucks off the street. Now that I don't believe comes from any of the citations in the record, but it has nothing to do with what the solid waste management plan said. Solid waste management
plan said isn't that evidence of negotiation? The negotiation doesn't have to bear fruit under the solid waste plan. It just has to go forward. So there was negotiation.
There was negotiation, and there was an agreement, according to Commissioner Doherty and Commissioner Diaz. So once there was an agreement, there was no opportunity for the city, without changing the solid waste management plan, to legislate in this area. Now, what the city says is that, well, they rejected it for other reasons, but the solid waste management plan doesn't give them the opportunity to do that. It doesn't say, well, you can reach an agreement, but if you don't like it because the sky is blue, you don't have to do it. You can legislate anyway. So for that reason, by legislating without, even though they reached an agreement, the city violated the solid waste management plan by going forward, and the law should be set aside.
But Council, this is Justice Gasmer. It seems to me that you're confusing a ceiling and a floor. The amount permitted was the ceiling, but the city didn't guarantee that amount of waste, and they were permitted to have a lesser amount of waste being delivered to that station.
Well, I'm not sure I understand the question, Justice Gasmer, but my point is this, that the solid waste management plan said the city had to reduce capacity by 6,000 tons. To 6,000 tons, whatever it was. The agreement did that. Once the agreement did that, there was no occasion for legislation. Even if the city wanted to do more, they couldn't reduce it more. They had achieved the goal of the solid waste management plan and done what it provided for. They could have changed it if they wanted to. They could have gone and changed the solid waste management plan. I'm not arguing that the council couldn't ultimately do what it wanted to do, but without changing the solid waste management plan, they couldn't do that. And they didn't change the solid waste management plan. So I would submit that for that reason alone, the local law 152.
But I think that the issue is that whether or not they were required to amend that in order to reduce the capacity further. And that's where I think I disagree with you. I don't see why they would be required to amend the plan in order to reduce the capacity further.
My argument, Justice Gesmer, is that they were required to amend the plan, the solid waste management plan, to do anything else with regard to capacity.
Okay.
Because
we disagree. Now I understand.
Okay.
So you're basically arguing they had to accept whatever proposal was agreed upon between the two parties, and if they chose not to accept that proposal, then they had to amend the plan.
Not quite, Your Honor. Okay. What I'm saying is that there was an agreement. Once there was an agreement on the solid waste management plan, there was no occasion for legislation. They couldn't. But
that's what I'm saying. Stop right there. So you're saying once there's an agreement between the two negotiating parties, that's it. That makes it the agreement. And the council, all they could do at that point, according to your argument, is then amend the plan.
That's right. But I'd go a little bit further. And a little bit further is this. What the council did here was not, at least according to the Corporation Council's brief, because this isn't, I don't believe this is from the record, but what the city did here was reject, the council refused to go forward with the agreement, even though there was one, because of other reasons
But were they,
unrelated
the question
capacity.
is, were they required to go forward with the agreement that was being proposed by the two parties? That's my first question.
I would put it a little differently, Your Honor. I would say that they were prohibited from legislating once there was an agreement.
So,
Because the plan says,
put another way, that means they have to accept it.
or they have to amend the solid waste management plan, which they didn't do.
That's what I said. So once the two parties agreed on it, then the only thing the city council could do is to amend the plan.
That's right, because they're bound by the plan, and the plan says you negotiate an agreement, and only if you don't negotiate an agreement, you can legislate. So the plan says.
Got it. All right.
Okay.
All
so
right.
Turning to seeker, I don't know how much time I have left.
No, actually, you're going to have to do that on your rebuttal time.
Okay.
All right. Ms. McCampbell?
Good morning, Your Honors. Afternoon, Your Honors. May it please the court, Amy McCampbell on behalf of respondents. Your Honors, Local Law 152 reduces the permitted capacity of commercial waste transfer stations in 4 of the city's community districts, the 4 community districts that bear the brunt of the burden of this industry.
We understand that. Could you address the argument by Mr. Spalzino with respect to the process? His argument, if I understand it correctly, is that once the two parties reach an agreement, the city council can only amend it if they don't want to accept it. So they didn't want to accept this. Were they then required, as Mr. Spalzino is arguing, to then amend the plan?
No, Your Honors, there is nothing in the solid waste management plan that prohibits the city council from legislating reductions of permitted capacity. In fact, the solid waste management plan explicitly contemplates that legislative reductions may be necessary here. But even if petitioners' read of the plan is credited here, Your Honor, the $6,000 ton per day negotiated reduction that they say occurred, it was never achieved. The testimony that opposing counsel is referring to is referencing oral agreements that were never memorialized. And the facility owners never applied for any reductions in their permitted capacity, nor did they amend their permits upon renewal to reduce their permitted capacity. So to the extent that one could read the solid waste management plan as contemplating legislation only if negotiations fail, the negotiations did fail here because the permitted capacity was never reduced. The Local Law 152, Your Honors, is fully consistent.
Was that agreement required to be reduced to writing in order to not be perceived as illusory or not a real agreement that had to be acted upon by the city?
Well, if there's no reductions in permitted capacity, then the negotiations haven't achieved that reduction. The facilities are allowed to transport a certain amount of waste per day under their permits, and if those amounts are not reduced, then they can continue to operate at their former limits, which was exactly what happened here for years and years and years following the solid waste management plan until the city enacted Local Law 152. Local Law 152 is fully consistent with the solid waste management plan. The solid waste management plan makes a commitment for the city to reduce the throughput in these community districts a meaningful amount to actually affect the conditions in these districts. And that is precisely what Local Law 152 does. If the city hadn't enacted Local Law 152, unfortunately, we would not have been in fulfillment of those commitments that we made in the 2006 Solid Waste Management Plan. And the environmental review for the Local Law 152, moreover, shows that the Local Law 152 is further consistent with the Solid Waste Management Plan because it would not impede the industry's ability to continue to operate in the city, which was the mentioned in the Solid Waste Management Plan as a condition.
Council, that negative declaration, that was premised on studies that were done. And as you know, the petitioners fault your analysis of slack capacity. And if that is wrong, if you calculate slack capacity in an incorrect manner, how can the EAS be valid?
Sure, Your Honor. So the projections of slack capacity were based by
a four-year average, and they're saying that a 4-year average is not probative.
Well, the 4-year average was based on the tonnage that the facilities report to the city. The facilities submit quarterly reports to the city that has to include the amount of waste that they're transporting. We took those quarterly reports and we averaged them to produce a tons per day. So it wasn't a number that we made up. It was based on the actual reported data by the facility owners themselves.
Didn't you include all 7 days of the week as well? And that's another problem with the math.
No, Your Honor. We based it on a 6-day-a-week assumption, which is consistent with the what is allowed under the law for these facilities to operate. It's also consistent with the hours in their permits and with the hours that are posted on many of the facilities. And this is explained in the affidavit from Department of Sanitation and the record. It was a 6-day-a-week assumption that we used, and that we use that to calculate the tons per day based on the reported tonnage from the facilities themselves. Moreover, Your Honor, the city used a variety of very conservative assumptions in making its future projections here. So, for example, when we looked at the waste and we calculated for projected waste in the future, we looked at the waste from economic boom years, 2014 to 2017. Even though in the Department of Sanitation's experience, more waste is produced in boom years and the economy is cyclical, waste goes up and down. Still, in order to ensure that we weren't underestimating waste demand and thus overestimating slack capacity, we used those boom years as a basis for our future projection. We also made a conservative assumption that waste demand would continue to grow at a steady, constant rate in the future. That was also a conservative assumption because, again, in the department's experience, the waste demand is more cyclical and tends to go up and down with the economy. We also made a conservative assumption that the amount of permitted capacity in the system would not increase, even though at the time the review was conducted, the Department of Sanitation had applications pending to increase the permitted capacity. So with all these very conservative assumptions, it's very unlikely that the estimates of slack capacity, that we could have underestimated slack capacity here. And moreover, the slack capacity that the EAS found was more than ample to accommodate the waste that would be displaced by local law 152. This wasn't a close call. There's a lot of slack capacity in the system, and that was based on our reasonable projections that we made in the EAS.
Thank you. Anything else?
I think that's it, Your Honors. Thank you so much.
Thank you so much. Mr. Spolzino, you have 2 minutes.
The conservative assumptions, Your Honor, are nowhere quantified in this analysis. So there's no basis for counsel to say the conservative assumptions made up for the quantitative failures. Solid waste doesn't flow on average, it flows every day. And so the idea that the 4-year average can be a basis for adjusting capacity and restricting capacity.
But counsel, we have to remember the standard of review, they have to be rational, not the best analysis.
Right, and I would suggest, Your Honor, that using a standard that has no application in the real world is not a rational basis for their determination. I'd also argue that they have to base their conclusions on available information. And with respect to job losses, the city never tried to even obtain actual information about jobs at these facilities and how that might be affected. They used handbooks and projections and that sort of thing, but never even tried to obtain actual information, even though they knew that there were 22 facilities that were affected by this law. They could have asked them.
Well, counsel, this is Justice Ginsburg. Doesn't that go back again to Justice Moulton's question that the standard isn't that they have to choose a particular methodology or what you consider the best methodology, as long as it's not an arbitrary or capricious methodology? And if they had some other way of calculating the approximate number of jobs at issue, they don't have to go out and count jobs, do they?
Well, the standard, Your Honor, is to take a hard look. And if there's available information that they chose not to look for.
That's the environmental standard, is to take a hard look at the environmental cost. But that doesn't mean that's not, the hard look and the arbitrary and capriciousness are different standards for different purposes.
Well, I believe that if there's the hard look standard overall requires that if there's information that's available that would answer the question and address the environmental impacts, they should get it, not avoid it.
I think it means that they have to take a hard look at the environmental impact, not that they have to count in some the manner you believe is most appropriate to decide what the environmental impact is. Is there any case that says that they have to follow a particular methodology in order to take a hard look at the environmental impact? I think it's quite to the contrary.
I don't have it off the top of my head, Justice Ginsburg, but I respectfully disagree that taking a hard look means you look at the available information, not just that information that is not what could answer the question that will define the environmental impact.
Thank you so much.
Thank you.
People, certain underwriters at Lloyd versus Bioenergy Development. Mr. Gonzalez, you have 12 minutes, sir.
Thank you, Your Honor. May it please the court, Matthew Gonzalez, counsel for appellants, certain underwriters at Lloyd's et al. Good afternoon. We've got several issues to cover today, spanning two separate appeals. So I'm going to try to focus on a few key points that are central to both. And I think consideration of these points reveals a theme. Judge Borak made an early procedural error when he ruled that he could not apply the policy terms and conditions to the appraisal award because the issue was not deemed to be before him. That error was then compounded into several subsequent errors, all of which deprived insurers of the right to apply the policy's terms and conditions to both the appraisal award and the remaining claims in this matter. These errors, and there were 6 of them, require reversal of those decisions. Judge Borak denied insurers' request to apply the policy's terms and conditions to the appraisal award on the basis that the issues of property damage were unrelated to the causes of action pled in insurer's complaint. But what the court failed to recognize is that in the amended answer with counterclaims, Bioenergy specifically alleged claims for property damage and failure to pay. It is undeniable that the issues insurers raised in their motion were related to causes of action pled before Judge Borak by virtue of Bioenergy's counterclaim.
Counsel, Justice Gassmer, I have a question. It seems to me that what you're describing as Justice Borak's errors have to do with his deference to the appraisal process, which is entitled to the same deference that an arbitration process is entitled to. So that I'm not sure that it's an error so much as a conclusion that I guess I'm troubled by the fact that it seems to me that what you're describing as his errors were really his deference to this process and not treating it in the same way he would, it's the same way we would treat a trial decision. He's entitled to give that process itself a high level of deference. Isn't that really what you're complaining about?
Well, in this instance, Your Honor, Judge Borak, the panel wasn't permitted to decide issues of coverage, and that was really the question here.
Counsel, let me add to that question then, because let's say he was incorrect in saying it had to be pled, and you're correct that it was brought up anyway. How do you win on the merits if we get to the merits of that issue?
Your Honor, there are terms and conditions in the policy that must be applied to the award. Insurers in this instance aren't challenging the amount of the award from the appraisal panel.
Counsel, didn't you specifically, not you specifically, but didn't your client agree to the way that this appraisal was set up? And wasn't the issue of what is buildings under the policy and what damages what specifically submitted to the appraisers under the appraisal process? And didn't the insurers agree to that, to submitting those questions to the appraisers?
No, Your Honor. All that was asked of the appraisal panel was to determine the amount of the damaged property. The issue.
Yes, but you asked them to separate it between the categories, did you not?
Well, we had to, Your Honor, for this very purpose.
All right, fine. For whatever reason, you asked them to separate them into categories, and now you're taking issue with one of the categories. Am I right?
Yes, Your Honor. We needed to understand how they allocated it so that we could then apply the terms and conditions that were contractually agreed to by the parties to the award.
So once you agreed that they could make that determination, how can you then say that you're not bound by that determination? Because you specifically asked them to make the very determination that you are now seeking to challenge.
Well, respectfully, Your Honor, we didn't ask them to make a determination as to which items of property were buildings and which items of property were machinery and contents. We asked that question so that we could get clarification of the issue. All that was asked of them was to determine the amount of the damaged property. So that.
And isn't that exactly what you're trying to challenge now? They made that determination that you asked them to make, and that is the determination you are now seeking to challenge and argue it was incorrect, which goes back to the earlier question about, don't we give the same deference to arbitration determinations if the parties agree that the arbitrator should decide that question, and this appraisal gets that same deference? So you asked them to make a determination, they made that determination, and now you're arguing you get to revisit it. And why should you be able to?
Your Honor, if we didn't ask them how they allocated the property, then we would have still had to ask the court to apply these sublimits in a certain way, right? The terms and the conditions of the policy don't disappear because you have an appraisal award. We need to apply those terms and conditions. And in this case, the parties agreed that there were going to be two sublimits that would apply to damage. One for buildings, of which there were none that were damaged, and one for machinery and contents. And if we didn't ask for clarification,
necessarily, in order for the appraisers, it seems to me, in order to break down the damages, the purported damages, into two categories, they first had to make the initial determination of whether something fell into the building category or into the machinery category. No?
Well, it's to the extent they did do that, I would note.
Well, obviously they did that because you sought clarity on that issue.
Correct.
And so if during the process you failed to assert what your client believed constituted buildings for the category, then isn't that on you?
Well, no, Your Honor. The only thing that we asserted in the appraisal was reference to the valuation provision. And the reason why that was relevant was because the parties agreed to certain values for certain property, items of property. And that is a necessary measurement, a necessary indicator for the panel to consider as to what what that damaged property might be worth. We never asked them.
Am I understanding it correctly? Because I was confused. Based on my read of the record, the defendants here purchased insurance under two categories, for buildings and for equipment and machinery, correct?
Correct.
And your client underwrote those policies and accepted fees for that coverage, right?
Correct.
And now your client is saying that very thing that you paid for in insurance actually doesn't exist. You have no buildings. So this company accepted insurance for buildings that they now say don't exist. Do I have this right?
No, Your Honor. They do have buildings. And Mr. Agarwal, in his affidavit, it's in the record at page 535, identifies all of the buildings in the property that were insured under this program. Unfortunately, none of them were damaged in this, or fortunately for them, but unfortunately for purposes of argument, none of them were damaged in this fire. There is no single item of property.
Yeah, so this is where I keep having the same trouble. That's your argument, but they rejected it. You said to the panel, make the allocation as between the buildings and the equipment. Please make that allocation. And now you're saying, I disagree with what the panel did, but you agreed that they should decide that issue. And now you're saying they decided it wrongly, and you get to come back to us and have a second bite at the apple. And that seems contrary to well-established law about the binding nature of the appraisal process.
Your Honor, we didn't ask them to make that allocation. We asked them if they did and how they did it. If we never asked that question, how could we have then gone to the court and say we have a $10.2 million sublimit that needs to be applied to this award if we first don't know how they allocated those damages?
You never asked them the question. You could then you could at least make a good faith and argument to the court. This was not an appropriate question for the appraiser. We never asked the appraiser to decide this because it's an interpretation of the policy question, which you court should decide. And that argument could have been or may have been viable if you had never initially let the arbitrator or the appraisers decide that question. But you charted your course of giving them the question.
Your Honor, all we did was ask if they did it. We didn't ask them to do it. And I understand. I understand where you are on that, and I don't mean to belabor that point, but it is a significant point on this issue. We did not, and I'll take it one step back. If you look at the record at page 65 on this issue, Judge Borak momentarily granted insurer's motion on this point and applied the sublimits, but they only to reverse course at the suggestion that it wasn't proper for him to do so. And that's where I get back to. He had actually decided on the merits, but then said, wait, I can't do that because this issue was improperly before me. And that's where all of this stems from. This issue was before him by virtue of Bioenergy's counterclaim. And at that point, Judge Borak may have reached the same decision that the appraisal panel reached, but he elected not to do so, and that's where the error occurred.
Was that counterclaim asserted prior to the decision in the appraisal process?
So prior to the decision in the appraisal process, there was a declaratory judgment action on two limited issues: the buildings issue and the misrepresentation issues had not presented themselves yet because those didn't develop until the appraisal process. But insurers never answered the counterclaim until after the appraisal process was over because there was a motion to dismiss that was filed that was ultimately reversed. And so the first opportunity insurers had to file and answer an affirmative defenses was 3 months after the appraisal award in March of 2019. And that was the first time the insurers raised the issue of the buildings and machinery and contents and raised the issue of misrepresentation.
Counsel, you moved for summary judgment, right, for a declaration that none of the damaged properties was buildings. That was part of the relief you were seeking, right?
Yes, Your Honor.
So that issue was before the court. Why wouldn't the court then have the authority to say, as it did, that the court couldn't decide that issue because the arbitrator decided that issue?
Your Honor, that's not what Judge Borak said. He said, I can't because this isn't before me. That was the first procedural error. He elected not to do so.
But why would there be a different outcome? Let's put it that way. Let's say he did address the issue. How do you get around that analysis?
Because what the term buildings means in an insurance policy is for the exclusive jurisdiction of the court. It's not for the panel to decide. And in fact, the panel wasn't even unanimous on what a building meant. What we were asking was the judge to provide a definition of that term, which could then be applied to the appraisal award. No, it is undisputable that there was not a building.
Why wouldn't there be an overturning of the appraisal award?
We're not asking to overturn.
Overturning what the appraiser specifically held.
Your Honor, we are not asking anyone to revisit the amount of the award. The number is 24 million. No one is disputing that. But it's significant because if there were no buildings that were damaged, what is relevant is how much the insurers owe under the agreement.
Right, but the appraiser, we're going in circles. The appraiser determined how much of the buildings were damaged. The appraisers made a specific determination how much of the buildings were damaged in the way that they ultimately issued their award.
And without providing any explanation as to how they define building, they did that. And that's
right,
not for
but they don't have to. Just the way an arbitrator does not have to give an explanation for what they did. There's no requirement under the law that an arbitrator or an appraiser explain the basis for the ruling. All they have to do is issue the ruling, and then the courts give it deference as long as that issue is squarely put before the appraiser. And there's no question on this record that you put that issue before the appraisers. You said to them, tell us how much of it was one thing and how much of it was the other thing.
Your Honor, the difference between the appraisal and the arbitrator is the arbitrator is allowed to make legal rulings. The appraiser is limited to quantum. How much does a particular vessel cost to repair? And that is not in dispute. We are not questioning their decision on that.
Thank you. You'll have time on rebuttal. Mr. Ortiz.
Thank you, Your Honor. May it please the court, Dennis Ortiz. I represent the respondents. I'll refer to them collectively as Bioenergy. As Your Honors have seemed to understand, we're here today on the appeals of binding insurance appraisal awards solely because the insurers are dissatisfied with the result of an issue that they specifically asked the appraisers to decide. Just let me make one clarification about the policies. I know one of your
Counsel,
honors mentioned.
Can you tell me if during the appraisal proceedings, was the evidence submitted and bifurcated in a way that it was being put forth before the appraisers in one or either of these two categories?
Your Honor, this issue was considered extensively by the panel. I direct your honors to the record at pages 697 to 718. That is a PowerPoint that insurers submitted raising this issue about what's buildings versus what is machinery and contents. They argued policy application in that PowerPoint. After that, there were Bioenergy, of course, had to respond and offer counter arguments. The panel asked pointed questions to the parties. The panel then asked for additional submissions for the parties. They met with the parties' respective building consultants. They followed up with additional requests for information. Your Honors, this process went on for months on this particular issue, and it was all at the request of the insurers that this issue be decided. So to say and to suggest that the insurers only asked whether the panel had made the allocation is really disingenuous. And you can see also in the record at page 720, that's Mr. Gonzalez's email to the panel saying it's unclear how the panel allocated the damaged property between buildings and machinery and contents. Were all the items damaged considered building? If not, what items of property fit into each category? That is not a request, did you do it? That is, how did you do it? Because we argued it for months and months and months, and now we are unpleased with the result, and we would like a second bite at the apple. So we'll go to Justice Borak, and we'll invent this argument that there is somehow a policy interpretation issue here, which of course there is not.
Would you like to address the issue on the related case, the motion to vacate judgment?
Yes, Your Honor. On the misrepresentation point, is that what you're referring to, Your Honor?
Yes.
Yes. Oh, apologies. So having lost on the limits issue, the insurers essentially went back to the drawing board and they said, we got to conjure up a new argument to avoid payment. And they came up with this idea that Bioenergy somehow misrepresented the value of the plant when it purchased the policy, even though the insurers underwrote exactly the amount of coverage to which Bioenergy has claimed it is entitled in this case. It's undisputed that the insurers have the burden of proving through admissible evidence that Bioenergy made a misrepresentation about the plant's value and that the misrepresentation was material. And as the Supreme Court correctly found, they failed on both accounts. First, they offered no admissible evidence in support of their misrepresentation defense. We explained that issue at length in our brief at pages 21 to 36. I respectfully refer your honors to those pages on that point. But let me address materiality. Well, first, there was no misrepresentation here as a matter of law. I'll get to that in a minute. But more importantly, as the Supreme Court found, there was simply no material misrepresentation as a matter of law. Under New York law, in order to show material misrepresentation, insurers have to show that they would not have issued the contract if they knew the truth. And they have to make that showing through documentary proof of underwriting practice, such as underwriting guidelines, and proof of underwriting practices with respect to applicants with similar histories. They provided neither. Therefore, they failed to raise even an issue of fact with respect to materiality. But more importantly, with these types of policies, these scheduled policies or stated value policies, it's simply not possible as a matter of law to misrepresent your values. The policies here, they insure a single plant for a single stated value. That is a scheduled policy. When the values are understated in that kind of policy, there's no material misrepresentation. All it means is that the policyholder then bears any risk of underinsurance. And why is that? Because the insurance company is never liable for more than the precise limits that it fully considered during the underwriting process and agreed to sell for specified premium. Now, blanket policies, those are different. So blanket policies, they'll typically insure a number of buildings for a very large single limit that would apply equally over all of the buildings. So if the values of the buildings are understated, that could lead to the insurance company paying in excess of what it reasonably believed its exposure to be. That is the context in which insurance companies typically argue this point, that you failed to state your values accurately. Now I'm exposed beyond what I had reasonably considered. But the policies here, they're not blanket. They insure a single plant for a schedule of values that the insurer specifically underwrote and on which they base their premium. And Bioenergy does not seek coverage for a penny more than what the underwriters underwrote. And other courts, including the Supreme Court of Texas, have recognized that underinsuring values on a schedule of policies like this only means that the policyholder takes on any risk of uninsured risk. The last point I'll mention, Your Honors, is with respect to the misrepresentation. Again, they failed to raise an issue of fact, even that there was a misrepresentation. The plant's value is all concentrated in a very small area. It's not equally spread around the property. It's the storage, process, and wastewater section of the plant. That was the area that was affected by the fire, and it comprised the overwhelming majority of the plant's value. The areas that were undamaged by the fire consisted mainly of abandoned buildings. They had no value, and they were not even used in Bioenergy's operations. So there's no evidence in the record that disputes that fact. And the way these policies work, by operation of the escalation clause, Bioenergy purchased insurance, property damage insurance, with a range at not less than $26 million, and it could be escalated up to $32.5 million. And when you combine what the appraisal panel found as to the value of the property damage with the $3.3 million of building value that they say we failed to include, you're still on the low end of that range. There's still over $4.5 million of cushion of value that's not accounted for, that goes below the maximum limit that they underwrote. Significantly, during the appraisal, the insurer's own consultants, their building consultants, they valued the damage at $10 million less than the appraisal panel had found. So put that into context. Imagine if Bioenergy hired the insurer's consultants to value the plant for purposes of the purchasing insurance. They would have advised Bioenergy to state its value substantially less than Bioenergy actually did. So under these circumstances, there's simply no evidence in the record to support that insurers could ever demonstrate that Bioenergy made a material misrepresentation in its statement of values. And as I already described, as a matter of law, they could never demonstrate materiality. Thank you for your time.
Thank you so much. Mr. Gonzalez, you have 3 minutes.
Thank you, Your Honor. And I'll try to go quick. There was a lot to cover there because I didn't get to address the misrepresentation on the front end.
You have 3 minutes. Okay.
All right. Well, the parties were never allowed the opportunity to take discovery on this issue. And it is undeniable in the materials that were provided during the course of the appraisal that Bioenergy misrepresented the values of its facility when securing coverage. They insisted that the value of the facility was $26 million. And that to ensure
even if that were the case, what difference would it make? In light of the kind of policy at issue here, what difference does it make?
They asserted that the entire facility was worth $26 million, but when a third of the property—
my question was, what difference does it make?
I apologize, Ron, I'm getting there. A third of the property was damaged, and they claimed $28 million. To insure the entire facility, to be over-insuring the entire facility at $26 million, when 1/3 of it is damaged, and the claim is $28 million, demonstrates the materiality of that misrepresentation by itself. Not to mention their own tax documents identify undamaged property in excess of $3 million. The escalation clause that counsel raised puts the cart before the horse a little bit, because the escalation clause applies after the loss occurs. The misrepresentation here occurred during the underwriting, and Bioenergy should not be allowed to avoid the consequences of a misrepresentation that induced insurers into this contract, because the claimed loss to a fraction of the facility was within a certain percentage above the total values provided by the entire plant. This renders meaningless the contractually agreed provision acknowledging the consequences of a misrepresentation. That's why we have this in there. We trust you, okay? We trust you that the values you report are accurate. But if they're not, or if you make some other misrepresentation that is material, and the values are deemed material under New York law, they both go to the amount of risk that's insured and the type of risk. And these were all documented in the underwriting guidelines that were provided, which are business records.
Counsel, what evidence do you give us to the value of the plant? What evidence does your client provide as to what the plant really is worth, since you're claiming it was undervalued?
Your Honor, we didn't appraise it before the loss. That isn't what we do.
But even now, what's your evidence right now to support your allegation that it was undervalued?
The evidence is, because we weren't allowed the opportunity to take discovery, is in the materials that were provided during the course of the appraisal, which is that 1/3 of the property damage exceeded the total value that we were told was over-insuring the entire facility. At the very least, that raises a question of fact as to whether or not there was a material misrepresentation.
Counsel, when you talk about discovery, are you talking about the kind of discovery you would have been permitted in a court proceeding, or the kind of discovery that is permitted in this kind of appraisal proceeding?
This wasn't
it's a very different thing. I'm not sure what it is that would have entitled you to the kind of discovery that you're now claiming you were entitled to in this type of proceeding.
This is an affirmative defense to the counterclaims that were raised by Bioenergy. We're talking about in the litigation. This misrepresentation wasn't an issue for the panel. It would have been improper to ask the panel to decide issues of misrepresentation. The only information we had, though, to rely on when the court ordered us to, the parties to file motions without any discovery, was the information that we had gathered during the course of the appraisal. We would have liked to pose the broker, for example. There's evidence from the appraisal that the broker communicated directly to the underwriters as to the extent of the coverage that was requested by the insured. We should have been afforded the opportunity to ask those questions.
Thank you so much.
Thank you, Your Honor.
And last but not least, the Non-Human Rights Project, Inc., on behalf of Happy versus James Breheny. Mr. Wise.
Thank you, Your Honor. May it please the court. My name is Stephen Wise. I represent Happy, who is an elephant who has been imprisoned on 1 acre of land in the Bronx Zoo for more than 40 years. The Third Department's decision in what we call Lavery 1, which this court relied upon in dicta, stated that all rights require a capacity for duties that no non-human animals can have. But that's not true, and therefore this court is not bound by the Third Department's reasoning, as stare decisis does not apply when the law is either misunderstood or misapplied or contrary to reason. The Third Department made 3 serious errors that disqualify it from stare decisis. First, it quoted John Chipman Gray as saying that the legal meaning of a person is a subject of legal rights and duties. But blacks omitted what Gray meant when he said that. On the same page, he wrote that one who has rights but not duties, or one who has duties but not rights, is a person. Gray further wrote that animals may be legal persons either because they possess rights or they're subject to duties. The second error that blacks made was that they quoted Salmon on jurisprudence as stating that a person is any being whom the law regards as capable of rights and duties. When the Non-Human Rights Project looked up Salmon and saw that he had actually written rights or duties, it informed Black's editor-in-chief that blacks had made an error, and he agreed. Therefore, when a new edition of Blacks came out in 2019, it correctly quoted Salmon as stating that a person is any being whom the law regards as capable of rights or duties, and it said any being that is so capable is a person, whether a human being or not. Now, Judge Fahey, in his concurring opinion, noted that even if animals cannot bear duties, well, the same is true of human infants or comatose human adults, but they can seek habeas corpus. then following Judge Fahey and Blacks and Gray, and frankly, every other jurisprudential author who's ever written on it, the Fourth Department in Grades in 2018 stated the obvious, which that it's common knowledge that personhood can and sometimes does attach to non-human entities like animals. The social contract was the subject of the Third Department's third error. They said that the social contract means that society extends rights in exchange for an agreement to submit to social responsibilities. However, as the philosopher's amicus said, social contract means that we're all born with rights. The state doesn't give us rights. We're born with them, and that upon entering into a social contract, we give up natural rights that we already have. In other words, social contract creates citizens, it does not create persons. Thus, the Connecticut Supreme Court, in the case of Moore versus Ganem, wrote that social contract theory posits that all individuals are born with certain natural rights and that people enter into a social contract with their government. Yes, Your Honor.
You're arguing by analogy, and this is the only analogy you've got, I guess. But it still doesn't answer the question why a paradigm that was created for one species could possibly apply to another one.
Justice Fahey spoke of that. Justice Fahey said that, and in his concurring opinion on the appeal from this court, Justice Fahey said that the important question is not whether a non-human animal fits the definition of person, but whether she has the right to liberty protected by habeas corpus. And he wrote that the question of whether a cognitively complex and autonomous being, which the evidence shows that Happy is, has the right to bodily liberty is a deep dilemma of ethics and policy.
That's no question. But the word is used that's used in the habeas statute is person.
Well, Judge, that's what he's saying, is that the issue is not whether you're a person. The first issue is not whether you are a person, and if you are, you then see whether you have the right to bodily liberty. As Judge Fahey notes, the question is whether she has the right to liberty protected by habeas corpus. If the answer is yes, then she's automatically a person. And also, because any person, and anytime any entity has a right, that entity is automatically a person. So the reason that Judge Fahey criticized both this court and the Third Department was that they failed to take policy and ethics into consideration in determining a chimpanzee's right to bodily liberty. And instead, they based their decision, as Judge Fahey said, on nothing more than the premise that a chimpanzee is not a member of the human species. Judge Fahey noted that the right to bodily liberty derives
Counsel,
not
this is Judge Owen. I have a question. I'm hearing your arguments here. Isn't all this better suited for the legislature to act on? Because these are all policy, these are all very, very substantive issues here that really weighs on a whole host of things. And I'm not unsympathetic to what I'm very sympathetic to what you're saying here, but I'm not so sure that we're equipped to handle these this is more of a legislative area where they should be thinking of perhaps changing the habeas proceedings, more in line of what your arguments are. That's where it should be. That's where it should go, right? That's where the focuses of this push should be.
No, actually, the Court of Appeals has rejected the argument that common law change should come from the legislature. This case is a common law writ of habeas corpus based upon the common law right to bodily liberty. They said it is the court's duty to make these sorts of decisions in a field peculiarly non-statutory. This is uniquely true with habeas corpus because, as the Court of Appeals said in People versus Tweed, as the writ cannot be abrogated.
While I may agree with you on that this is common law, but it still doesn't change the fact that the legislature is probably better suited for addressing this kind of issue in terms of carving out specific statutory language to protect your client or other clients in this kind of situation. That's what I'm going at.
If I may, the writ of habeas corpus and the right to bodily liberty are not statutory in New York. They are common law. And
you're not hearing what I'm saying. I'm not disagreeing with you. Let's just say I agree with you, but there's nothing to stop the legislature from entering this area and creating some statutory remedy that would sort of ameliorate all these arguments. We have statutes that talk about protecting animals and their well-being. We have also laws to protect them from inhumane treatment. There's nothing that prevents the legislature then to even further extend protection for those animals who are in captivity that should be not in captivity anymore. That's what I'm saying. I'm not disagreeing about the common law and all that. I'm saying that what you're seeking, the remedy you're seeking, I think is best suited to be addressed in the legislative forum. That's what I'm proposing.
I'm not clear that that it is indeed a matter for the legislature. Even the word person in Article 70 it's CPLR Article 70. It's a procedural issue that refers back.
You're telling me the legislature should never even pass laws that protect inhumane treatment of animals, and that the legislature shouldn't even be entering that area. That all this can be done by the courts. That all those statutes that provide for protection of animals is just really unnecessary or shouldn't have been even delved into by the legislature. That's the sense I get.
If I may, Your Honor,
yeah.
Animal welfare is a matter for the legislature. The rights of any entity is a matter for the courts in the state of New York. And common law habeas corpus is in spades a matter not for the legislature, and it never has been for the legislature. It's always been a matter for the courts.
Judge Gesmer, if you could hold your question for rebuttal, we are way over time.
Sure, no problem.
Okay, thank you. All right, Mr. Manning, you have 4 minutes.
Thank you, Your Honor. Let me first turn to Justice Oing's point about the legislative preference. The Non-Human Rights Project, rather than having a second bite at the apple, to borrow a phrase from Justice Kern, has now had 5 bites at the apple. 5 times courts, including this court, have told the Non-Human Rights Project that the place to seek a remedy is the legislature, and 5 times they've chosen not to go there. Imagine the number of statutes that would have to be rewritten for this court to deem animals persons under the law. It's hard to imagine how many different legislative enactments are affected. Certainly the Animal Welfare Act, the Agriculture and Markets Law, as well as Justice Moulton pointed out, CPLR Article 70. So it belongs in the legislature. This court previously determined that in the Lavery 2 case, on which Justice Mazonet sat on that panel, and it should be in the legislature. Furthermore, the Non-Human Rights Project has had 5 bites at coming to court and getting this legal issue determined. 4 prior unsuccessful cases, and the reason they brought this case was they tried to circumvent this court by bringing it upstate to get a judge in the 4th Department to take a different look at the case. The trial justice in Orleans County sent the case screaming back to Bronx County, which is where it belonged, and Judge Tewitt has decided to dismiss the petition. We think the dismissal of the petition was correct under this court's decision in Lavery 2, as well as the 3rd Department's decision in Lavery 1. From our standpoint, what the amicus briefs in this case show is the level of interest that others who are not parties to this case have in the particular issue, to go back to Justice Oing's point, and a legislative hearing where they can have notice that's fair to people, that people can come in and express their views. The ability to conduct legislative hearings certainly would fully vet the concept that's being proposed by the Non-Human Rights Project. It simply isn't part of the law of habeas corpus. A final point I'll make is courts are designed to decide controversies. In this case, there's absolutely no controversy about the treatment and the living conditions of Happy the elephant. While the Non-Human Rights Project does not like it, the reality is it's not illegal for Happy to be at the Bronx Zoo, and we have 3 affidavits. We have it from the director of the zoo, James Brahini, who's a respondent. We have it from the chief veterinarian and from the general curator as well, Patrick Thomas, describing in detail, based on personal knowledge, the very good conditions that Happy the elephant was in. There's no reason to change her circumstances, and all the appellate divisions, including this one, have determined that habeas corpus is inappropriate for a change in conditions under any circumstance. And on that, we'll rest.
Thank you.
If I may, Your Honor.
You have 2 minutes, sir.
Thank you.
Counsel, this Gesmer, I'd like to ask a question. First of all, let me preface it by saying that I have the greatest respect for the intelligence and particularly the emotional intelligence of elephants. But one of the arguments you made, it seems to me, is that Happy has the right to bodily liberty, and therefore she's entitled to be protected by habeas corpus, which is extended to persons, and therefore that she is a person. Does that mean that she would have all the rights? If we decided in your favor, does that mean that she would have all the rights of personhood in our country, including, for example, the right to vote?
Thank you for asking. No, she wouldn't have any rights at all, except the right to bodily liberty protected by a writ of habeas corpus.
Why wouldn't she have all the rights of a person once we decide she's a person?
Because there's no such thing as having all the rights of a person. There's many different kinds of persons, and they have different kinds of rights. So, for example, as we talked about the pet trust.
But then again, we go back to the legislative issue. Who gets to decide which rights which animals have and what rights animals don't have? So are wild animals less protected than domesticated animals? I mean, there are a plethora of issues that get raised by this issue.
With great respect, Your Honor, that is not understanding what we are seeking. We are simply
Thank you for that.
What we are seeking, with great respect, what we are seeking is the right to bodily liberty of an elephant. At that point, and once she has the right to bodily liberty, at that point she automatically becomes a person for purposes of any statute. Now, the pet trust statute in New York has given non-human animals personhood for 25 years by making them beneficiaries of trusts. But yet you don't file lawsuits on their behalf for any other purpose. Neither would giving Happy the right to bodily liberty protected by habeas corpus permit Happy or any other non-human animal automatically to file any lawsuit seeking any other cause of action. Habeas corpus in New York is a uniquely common law.
Have a good day. This ends the session of the Appellate Division. Thank you.
Thank you, Your Honor.